Hello again, my friends. Today we are going to be discussing the filings that Letecia's defense team put up. They actually filed them on May 12th, but they were made public on May 18th. And I looked at the website again today, and I have not seen a response yet from the judge. So I do not know what's going to come of them. I do know that they have to be addressed in some manner. The first document is D10, Motion to Continue Preliminary Hearing. And it has a little intro, and then it begins with number 1. Ms. Stauch moves to continue the preliminary hearing and proof evident presumptive great hearing in this case because she is unable to meet with her defense counsel due to the COVID-19 pandemic and restrictions at the Colorado Springs Criminal Justice Center. A. Ms. Stauch is being held at the Colorado Springs Criminal Justice Center, CJC. She is, and then the next line is redacted. Ms. Stauch is charged with 2 counts of first-degree murder. Ms. Stauch is being held without the ability to post bond due to the nature of her charges. B. The defense has diligently met with Ms. Stauch to review discovery with her and prepare for the upcoming hearing. Since March 11th, 2020, the defense team has been meeting with Ms. Stauch entirely by online video visitation. From March 11th to May 4th, the jail permitted counsel to meet with Ms. Stauch via online video for 1 to 2 hours at a time, approximately 3 to 4 days per week. On May 4th, 2020, for reasons that are unclear to the defense, the Colorado Springs Justice Center suddenly stopped allowing video visitation for professional visits to inmates housed in redacted. See attached Exhibit A, and attached Exhibit A was not made public, so I don't know what that is. D. It is unclear what prompted this change in policy at CJC. The staff at the jail has informed defense counsel that the only way for counsel to speak to Ms. Stauch is to go in person to the jail and to meet with Ms. Stauch in an attorney room with glass in between counsel and Ms. Stauch and a mandatory closed trap. Phone, video, and contact visits have been prohibited pursuant to the new jail visitation policy. While the new policy prohibiting professional video visits and limiting in-person visits was issued formally on May 6, 2020, counsel has not been permitted to conduct a video visit with Ms. Stauch since April 30th, 2020. E. Counsel was permitted by jail staff to conduct a brief phone conversation with Ms. Stauch on May 12, 2020, in order to advise her of this motion to continue. Ms. Stauch has agreed to request this continuance based on the grounds cited in this motion. F. Counsel is aware of the challenges that confront the jail staff during the COVID-19. In consideration of public health guidelines and the staffing challenges at the jail, counsel contacted the CJC day shift commander, Lieutenant Eric Carnell, and suggested a pre-scheduled fixed time for video visits so that staffing could be predictably arranged for video visits with Ms. Stauch. Counsel alternatively suggested that Ms. Stauch be able to use a locked contact room with a portable video visitation booth so that deputies would not have to sit with her during her visits, or that Ms. Stauch be permitted phone calls to counsel's cell phone. The entire defense team has made themselves available any time of the day to meet with Ms. Stauch and accommodate the staffing difficulties at the jail. All suggestions short of requiring the defense team to enter the jail and visit Ms. Stauch in person and thus risk the spread of COVID-19 have been denied. G. On April 29th, 2020, the day shift commander at the jail told defense counsel Catherine Strobel that CJC would not accommodate a predetermined video visitation schedule so that Ms. Stauch could meet with her counsel because there was too many, quote, other circumstances, unquote. The commander did not tell counsel what those circumstances were that prohibited a video visitation meeting between Ms. Stauch and her defense counsel. The commander informed counsel that CJC cannot and will not allow for a set time for Ms. Stauch to meet with counsel via video because of her security status and the limitations on staffing at the jail. The commander further advised Ms. Strobel that it is difficult and time-consuming to transport Ms. Stauch to video visits. H. The prohibition on visitation between Ms. Stauch and her defense team has reached the point that requires court intervention. To date, the defense has received approximately 19,902 pages of paper discovery and over 250 items of media discovery, most of which contain multiple separate media files such as audio files, photographs, or video files. It is vital that the defense team is able to review discovery with Ms. Stauch in order to provide Ms. Stauch effective assistance of counsel pursuant to the ABA guidelines, Amendment 6 of the United States Constitution, and Article 2, Section 16 of the Colorado Constitution. Ms. Stauch is entitled to be informed of the evidence against her and to review it with her attorneys in confidence prior to her preliminary hearing. I. Even if counsel were permitted to enter CJC in person to visit Ms. Stauch would only be allowed to view her discovery behind a glass window pane, and she would be unable to hear any audio files or watch any video due to limitations of the attorney booths at the jail. The May 6th policy in Exhibit A prohibits electronics, such as laptops and phones, without a court order, so no digital discovery would be permitted absent a court order. And then paragraphs J, K, L, M, N, and O all go into statistics about policies regarding pandemic influenza, etc., since there's no precedent for COVID, and then also some statistics for COVID. And number 2, counsel is not prepared to proceed to preliminary hearing because the pandemic has prevented the defense team from adequately preparing for this hearing. A. Restrictions on travel due to the COVID-19 pandemic have prohibited the defense from investigating this case. The investigation surrounding the allegations in this case span across the state of Colorado and across the country to South Carolina and Florida. To date, the prosecution has endorsed approximately 320 witnesses, and there are likely an exponentially greater number of witnesses that have yet to be endorsed by the prosecution and the defense in this case. B. The defense has been unable to travel to conduct any investigation in the above locations due to the ongoing pandemic. Defense investigators cannot conduct in-person interviews with witnesses, nor is it safe for investigators to go to locations of interest to this case or visit schools, churches, or businesses to interview witnesses and retrieve records due to the stay-at-home orders still in place throughout the state and the country. C. The ABA guidelines in capital cases require that counsel conduct thorough and independent investigations relating to issues of guilt, penalty, and mitigation. Counsel must independently investigate the circumstances of the crime and all evidence purporting to inculpate the client. The defense lawyer's obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witnesses, but also searching for any other potential witnesses who might challenge the prosecution's version of events, and subjecting all forensic evidence to rigorous and independent scrutiny. Counsel should seek out and interview potential witnesses, including but not limited to eyewitnesses or other witnesses. The defense is unable to fulfill their obligations to Ms. Stauch under the ABA guidelines due to the COVID-19 pandemic. 3. The defense has not received necessary discovery that will be at issue during the preliminary hearing and proof evident presumptive great hearing. A. The autopsy report in this case has not been discovered to the defense. Despite their efforts to obtain it, the prosecution has provided no time frame for when the defense can expect to receive the autopsy report. Therefore, the defense has not been provided with details or documentation relating to the cause of death, manner of death, or any of the vital information contained in the autopsy report. Once the autopsy report is received, the defense will require more time than is allotted before the currently scheduled hearing to review, research, and prepare to litigate the results contained therein during the preliminary hearing in this case. B. Among other missing pieces of discovery, DNA results are still outstanding on a number of key pieces of evidence and, redacted, have not been disclosed to the defense. C and D are basically explaining why they need more time. And then it goes to 4. The current Chief Justice orders related to the COVID-19 pandemic that are in place to protect the health and safety of all parties contravene Ms. Stauch's right to effective assistance of counsel to participate in her defense and her right to face-to-face confrontation. A. Not only do the current limitations on professional visitation at the jail ensure that Ms. Stauch will be unable to see her attorneys in the month prior to her currently scheduled preliminary hearing and proof evident presumptive great hearing, but also public health guidelines, the Chief Justice orders both from the Colorado Supreme Court and the El Paso Chief Judge all require Ms. Stauch to be seated at least 6 feet apart from her counsel during any court proceeding. The social distancing requirements will make it impossible for Ms. Stauch to ask questions of her attorneys in confidence or assist in her defense throughout the hearing. B. Counsel and the rest of the defense team will be unable to confer with each other during the hearing without risking the spread of COVID-19 because communicating in the midst of a hearing would require less than 6 feet of distance between each member of the defense team. C. The requirement that counsel and witnesses wear masks will limit effective cross-examination because the faces of everyone in the courtroom will be obscured. The benefits of in-person testimony at hearings cannot be overstated. Having the ability to see one's facial expressions to determine their veracity and to see how a person behaves when subjected to in-person cross-examination is a promise of the United States judicial system that Ms. Stauch does not wish to sacrifice. Thus, it is her request that this court continue this hearing until such a time that the Confrontation Clause in the Colorado and United States Constitutions can be upheld to its ideal. And 5, I don't know if it says proving or providing because it says proviing. A public hearing will place the lives of the community, courthouse staff, the jail staff, all counsel, the families, and Ms. Stauch at risk. A. Courtroom size makes social distancing impossible in this case. The current safer at home mandate by Colorado Governor limits public gatherings to less than 10 people. That requirement necessitates limitations on which members of the defense team can attend the currently scheduled hearing on June 5th and 8th. And B, in addition to limitations on the number of people on the defense and prosecution teams, social distancing mandates will limit attendance anyone else who wishes to attend this hearing. When considering the required attendance of the court clerks, Ms. Stauch, her lawyers, and the prosecutors involved in this case, the advisory witnesses for each side, the number quickly exceeds 10 people. Therefore, no in-person observers will be permitted in the gallery of the courtroom itself for this hearing. Should members of Ms. Stauch's family, members of the victim's family, members of the public, and the press wish to observe this hearing in person, they will be prohibited from doing so pursuant to Governor Paulus's orders, the Supreme Court orders, the El Paso Chief Justice orders, CDPHE, WHO, and CDC guidelines. For the reasons stated above, the defense requests the court either grant this motion or schedule a hearing forthwith on the matter.